can you please call the hearing number for the record?
This is Commission Hearing Number 13 of 9th October 2019 in the case of 0013 Anthony Hunt, 0015 Antoine Ali, 0028 Alan Enista, 0096 Amon Chung Sang, 0122 Wok Jani.
Thank you. Can you please call the next witness?
Mr. Bernard Georges.
I, Bernard Georges,
Swear that the evidence I shall give
swear that the evidence I shall give
shall be the truth,
shall be the truth,
nothing but the truth,
nothing but the truth,
so help me God.
so help me God.
Thank you, Mr. Georges, for coming back today. Sorry about rescheduling you.
That's not a problem.
Yeah, sorry,
that's
we-
not a problem, madam. I'm
Thank
at
you.
the service of the Commission.
Thanks very much. So today we've asked you to give evidence in relation to case 0013, Mr. Hunt's case, as you were the lawyer that represented Mr. Hunt, and he's waived any privilege over those communications. In his complaint, he alleges that his property was compulsorily acquired by the government in the national interest in June 1986, parcel C1413. He claims that the compensation paid for the acquisition was inadequate and that his subsequent claim for compensation was denied on the grounds that he failed to abide by the time requirements of the transitional provisions as set out in Section 7 of the Seychelles Constitution. But he claims you represented his family and that you personally handed the letter seeking compensation to Mrs. Simone Millie, is that right, from the Ministry of Community Development. Subsequently, any attempt made to have some communications or some response has fallen on deaf ears. That's his. So the Commission would appreciate any evidence that you could give it in relation to his complaint, and in particular, if you can, the inadequacy of the compensation that was initially paid and whether or not he had a right to seek additional compensation. Thank you.
Thank you very much. Good afternoon, members of the Commission. I certainly acted for Mr. Hunt. I do not remember now whether Mr. Hunt was still alive at the time or whether it was his estate that I was dealing with, but certainly it was property of Mr. Harold Hunt. I, of course, dealt with a very large number of compulsory acquisitions at the time, and this was but one of them. And I unfortunately no longer have the file relating to the Hunt property because at some point I handed that back to Mrs. Hunt, who was seeking legal advice elsewhere. And I understand that the file has been mislaid somewhere. But I certainly do remember a number of things to do with the case. A claim for compensation was filed. Compensation was negotiated and compensation was paid. I have no further details in the absence of the file of the dates and the amounts. When the Constitution was promulgated in 1993 and Part 3 of Schedule 7 of the Constitution allowed dispossessed former owners of compulsorily acquired properties to submit a claim for additional compensation or for the return of any undeveloped property or any property in respect of which there were no plans for development. I lodged a claim for additional compensation for every single one of my former clients. Though,
Can I ask you, why was it seen as necessary to have that provision in the Constitution to pay people additional compensation?
thank you for that question. I reluctantly have to confess that I had something to do with it. I had appeared at the Constitutional Commission hearings, which were drafting the Constitution, and I had appeared there to speak on two topics, one of which was the matter of compulsory acquisition. Because I had dealt with so many of the cases during the period of acquisition, I felt that it was incumbent upon me to address the Commission and to seek some form of protection in the Constitution against a repetition of the wide-scale and very often unfair compulsory acquisitions. I duly appeared before the Constitutional Commission and made representations. The consequence of my and the appearance of several other persons on the same topic before the Commission was the enactment of the transitional provision in Schedule 7, Part 3. And there was a clear recognition by the framers of the Constitution that the whole system of compulsory acquisitions had been very unfairly carried out. Dispossessed owners had been very unfairly compensated in many respects, and that they needed redress. There needed to be redress. And we were very happy to see the constitutional commitment in Part 3 of Schedule 7, which gave great hope to persons who had been dispossessed that they would obtain the return of undeveloped property or compensation based on 1993 values, as opposed to the system of existing use value which had existed under the final or one of the final amendments to the Lands Acquisition Act.
Ask another question. Is it true that when land was acquired under that act, if you hadn't developed it, it was valued as worth nothing?
Correct. That's exactly it. At the beginning, the land was valued at market value. So everything was fine at the beginning. The Lands Acquisition Act went through a series of amendments, each time making life more difficult for those whose properties had been acquired. First of all, the method of calculating compensation was changed from the market value, that which is traditional between a willing buyer and a willing seller, and it went to what we called in common parlance the existing use value. So if there was no existing value, if the property was producing nothing, the value was consequently nothing. So an acre of land on Beauvalon Beach, for instance, which produced nothing, was valueless. And in many cases, wholly insubstantial sums of compensation were returned for large properties. I have many notes on the subject, which I'm very happy to share with the Commission occasion arising. But I give one example. The whole of the plateau, the flat area of Anse Royale, was owned by Mrs. Dauphin, Mrs. Z. Dauphin, Z. Jumeau, who had married Dr. Dauphin Senior, Mr. Dauphin, the surgeon. That was about 100 acres. It was agricultural land, but at the time it was compulsorily acquired. There was no agricultural value to the land because it wasn't being productively used. I acted for them. Nil return was put on the land, and the only thing that they got was the cost of the valuation of certain works on the land. I remember there was a wall, there might have been a well or a reservoir or something like that. That's all that was compensated. So that was the first amendment. There were others, but the one of significance was later that even that compensation was not paid in cash, and the government kept the option of paying it in a 20-year bond. And in many cases, the compensation was, as small as it was not paid in cash, but was spread over a very lengthy period of time.
My burning question is, in your observation or experience, what was the criteria that was applied to determine that land should be acquired in the national interest?
Well, I don't know that there was any criterion, or that there were any criteria at all. I maintain that it was purely arbitrary. Having said that, certain people were targeted because of their political affiliations. That is absolutely certain. Other properties were acquired because there was a need for all or part of it. But the problem there was that sometimes very large properties were acquired and only a small part of the property used. The rest of it was left abandoned. And the question that constantly arose was, why did you take it all when you only required a small part of it? A prime example was Barbaron's estate. 1,000 acres of land were acquired. And even today, a very insubstantial part of it has been developed. There were many such cases. There was really no rationale, I don't think.
But if I was a very strong supporter of the party and I had a lot of land, would I be at risk or not? Strong supporter.
Well, of the party in power? Well,
yeah, of the ruling party.
Numerous persons who were strong supporters were compulsorily acquired. I can mention the Deltel family in the south of the island. Several hundred acres of prime agricultural and tourism land, which baffled everybody. So there was in the minds of those people on the outside looking in, such as myself, there was no rationale at all. Some could be defended because some were clearly acquired for a public purpose or in the national interest, and some very clearly were not. And even amongst those properties that were compulsorily acquired for a particular reason, in many cases there was no reason for acquiring all of it. Acquiring part of it would have been considerably more defensible.
And Mr. Hunt's property?
Mr. Hunt's property was in an area of Mahé called Anse-aux-Poules Bleues, and it comprised a parcel of land going from the seashore across a flat part of plateau and with a hillside behind it. Your traditional large property, a wide foreshore, and about 20 meters or 30 meters behind the road, an extensive agricultural piece of flat plateau, and hillside behind it. It was acquired, and a claim was in due course drawn up and lodged, and compensation negotiated, and so far as I'm aware, paid. Within the constraints of the Lands Acquisition Act at the time, namely the method of valuing and of course the method of payment, which I can't remember at this point. Come 1993, when the transitional provisions were incorporated in the Constitution, as I said, I lodged a claim on behalf of each and every one of my previous clients, including those who had specifically instructed me not to claim further compensation. I felt, after discussion with a colleague of mine, Mr. Ramniklal Valabji, who also had a large number of clients who'd been compulsorily acquired, we decided that as lawyers, our first and primary duty was to preserve the rights of our clients, even against their own wishes, and lodge an application for a review in terms of the schedule, for a review of compensation, or for a return of land. He dealt with his clients, I dealt with mine, and together we covered the whole territory. Certainly there were other lawyers dealing with other clients, but he and I covered the bulk of the compulsorily acquired persons. Unfortunately, the constitutional commitment turned out to be a damp squid. And it very soon became clear that the government was not at all in good faith, and it dragged its feet, and continued to drag its feet for many years, over a decade. And finally, it was through actions in the Constitutional Court and elsewhere that the government was finally forced to come to terms with the commitment that it had given and set up the Lands Tribunal to try and deal with these matters. In exactly the same way as the compulsory acquisitions had been arbitrary, the decision to tackle cases under the constitutional commitment was equally arbitrary. Some were dealt with speedily, others were not dealt with at all. And I have here a number of quite a lengthy exchange of correspondence. Well, it's not an exchange really. It was pretty much a one-way correspondence from me to the ministry, urging the ministry to live up to its constitutional commitment and deal with the cases of compulsory acquisition. So Mr. Hunt's property would have been one of those that I had dealt with by means of lodging a separate application for review. And as it became apparent to me that the government was not, well, this wasn't the top priority of things for the government at the time, I made sure that all the applications that were lodged were either done by myself personally, in most cases they were, because I was a regular visitor to the ministry because of the sheer number of cases I was dealing with, or that we would make sure that the delivery was recorded.
Georges, bonsoir.
Bonsoir.
Une petite question pour clarifier. Ça,
Oui.
lettre qui disparaît
Oui.
dans le file, c'est dans le nom incident madame. Il n'y a pas de aucune explication qui n'a avec sa lettre. On a son nom là-dedans.
Madame Melly?
Oui.
Oui. Madame Melly, c'est sa madame qui nous interface avec. Il tient madame bien compétente, qui travaille dans le ministère. C'est lui qui nous deal avec pour tout sa bonne caisse. Et il est mon interlocuteur dans sa ministère. Il est interlocuteur avec tous les autres avocats qui te permettent claim compensation aussi. Et c'est avec lui qui sa bonne document tu gagnes remettre, including pour Monsieur Hunt.
And about how many cases do you think you bought?
Several dozen.
And they still haven't been resolved
Not
today?
all of them. Not all of them. I have the list here.
And today, though, isn't there, so you wouldn't get a 1993 value today if you were going to get compensated. Am I right? There was a decision that said you get today.
Current values, yes.
Current values.
Yes. At the time, of course, we focused on 1993 values because we thought that everything was going to be dealt with speedily. And a lot of these properties have been compulsorily acquired late 70s, but mostly early to mid 80s. So already most of them were being valued at values in 1993, when land values had substantially increased because of the return to the multi-party. Of course, there was hope and a bit of buoyancy in the country, so the land values had shot up, and everybody was very pleased to be claiming at 1993 values. But of course, then, because the process stalled, the court was compelled to move the goalposts and say that the values had to be calculated at the time compensation was being paid, because there had been another significant shift in land values by then. What I did was, starting in February 1994 and continuing for 2 or 3 years thereafter, I wrote to the ministry, Attention Director of Lands, who was in fact Miss Melly at the time, if I'm not mistaken, sending in lists of cases of properties compulsorily acquired. And in the first letter that I could find in my archives from February 1994, this wasn't, the time for lodging had not yet expired, because we had a year, I think, until it would have been June 1994. So in February 1994, I sent in a letter with 3 lists, 23, 12, and 5. So that's 30, 35, 40 cases then. And list 3 was a list of cases, applications for review that I would be making. That was in February 1994. The Hunt application was not contained in these 3 because some were still to be made. And I continued writing to the minister in April 1994, suggesting that given the sheer number of cases, that perhaps what they should do is to set up a unit within the ministry to deal with these cases, which of course fell on deaf ears, and it's only a couple of decades later that at the urging of the the Court of Appeal, that the government set up the Lens Tribunal, which I had anticipated would be needed in April 1994. I wrote again in March 1995 to the minister, deprecating the time that was being taken. I wrote in April 1995, again the following month, to seek a procedure. In May 1995, I wrote to the President to say, please, Mr. President, intervene and get some movement going. I wrote in June 1995 to remind the court that in a recent case, the case of Porglo Development, that my position had been completely vindicated and to please get on with it. I wrote in August 1995 to remind the minister or the principal secretary, then Mr. Nouris, that their method of proceeding was grossly unfair. And I mentioned 2 cases. A case of Mr. Marcel Telfair Savi, who was an old man in poor health, and we were trying to get him some compensation before he passed away. The next case that I mentioned was Mr. Julien Dauphin, who I understand appeared before you yesterday, saying that nothing had been done to his land since it was acquired, and now that he's asked for it back, he was informed that it was going to be developed, which I felt was seriously unfair. And I attached a schedule of cases broken down into 3 cases never compensated, cases under negotiation, and cases in which review of compensation was sought. And there appears Harold Hunt. So clearly, Mr. Hunt's claim had been lodged, and had been lodged properly and within time. I wrote again in October 1995 and again in December 1995. I finally got a response in November 1995 saying that the ministry hoped to be in a position to consider my claims by the latest 31st December 1996. So when I wrote in December 1995, I said, will you confirm that it will have completed in 1996 and not only have commenced by then? I wrote again in April 1996 saying that things were not moving fast enough and seeking responses. Again, attaching 3 lists in which parcel C1413 of Mr. Hunt was the very first on top of category A, which was that no response to the claim for compensation or application for review had been made. At no point did I ever receive a letter saying, well, why are you asking about Mr. Hunt? You haven't filed a claim for compensation. No such communication, or at least not in the papers that I've been able to find. I wrote again in July 1996 and again in December 1997, this time dividing the list into 2, not compensated or seeking the return of property. And in the first list, applicants not compensated, I've said in order of priority. Very first one, H.A. Hunt, parcel 1413, Anse Poule Bleu. Again, nothing to suggest, nothing back saying, well, we are not considering Mr. Hunt because there hasn't been no application. So that for me is a clear indication that the application was made in time, and if the letter was misplaced, it was misplaced in the ministry rather than elsewhere. But whether or not the application had been made, surely the constitutional commitment, I think, overshadowed any procedural irregularity. The government had said, we will negotiate in good faith. We will return property that's not been developed or in respect of which there is no plan for development. I found it unacceptable that the ministry would, in respect of one person out of so many, suggest that because no application had been made, that they were going to cross their arms and the person would have lost any hope of receiving any compensation.
And that is the current position of the ministry?
Well, that was the last position that the ministry took with me.
And how long ago was that?
Oh, this would have been then in the 90s.
Right, in
Yes.
the 90s.
And of course, most of those cases have not been resolved. We've only been able to resolve 2 or 3 of them over the period. And some persons went and attempted directly with the government to resolve their cases and did.
And do you think now the setting up of the land compensation tribunal will expedite this process, will help to make it happen at least?
Well, everything that can be done, I think, is a step in the right direction. The only problem is it's taken way too long. The government gave a commitment. It gave a very short period of time for people to claim, 1 year. And what is it? 25 years later, the bulk of these cases have not been resolved. And those that have were resolved only at Court of Appeal level. So they had to trickle all the way up the court system to the Court of Appeal before the Court of Appeal could tell the government to get on with it. And in one case, to set up a tribunal because they were tired of cases coming up before them to be resolved. The commitment which had been given and which brought in an enormous amount of hope for dispossessed persons was completely dashed by government's inaction, foot-dragging, and total lack of good faith. In some cases, they tried to argue that the commitment to return undeveloped property meant that if there was a plan to develop, albeit a vague and unascertained plan, that was sufficient for them not to return it. There was clear lack of goodwill.
Oh, I might be naive, but to work out how much land is worth, don't you just get some people to survey it and come up with a value against it? I mean, it seems to me like it's a pretty easy process.
Well, one would have hoped, and in these letters, and as I say, if you feel that they will be useful, I'm very happy to make copies and to let you have them. I keep reminding them of this, that this is not a big issue. This can be easily resolved. All you need is to be able to set up a unit in the ministry, and I'm happy to work with them. I've suggested that we could work after hours to make things happen. But the constitutional commitment was words on a page, by and large. And I must say that credit must go to Mr. Philippe Boulet, who, as a lawyer, took several cases all the way to the Court of Appeal and was successful in getting the government to move. You see, in the case of Mr. Hunt, as in many other cases, the government, I think, gave or sold or leased or transferred some of the land for farming purposes. There are clear indications that some of the land is being farmed. That's fine. But some of the land has not been used at all. In fact, the strip by the sea has not been developed, so why couldn't they just have returned that? And the same applies to numerous other properties.
Would you agree with me if you said that the fact that the adjoining property to Mr. Hunt's, which is much bigger, was never touched? If there was a need in that area for land, for whatever purposes, you take a land of 100 acres and you leave one of 1,000 acres, and purely because of the political affiliations of the people involved.
Well, I think that stares us in the face. It's clear. I didn't come here to speak for Mr. Julien Dauphin yet. I may if you want me to. But for me, one of the, and I said it to the government in writing at the time, one of the most heart-rending cases was Mr. Dauphin's. He had a small plot of land, well, certainly not 100 acres, he had a small plot of land on which he had built a souvenir shop, a restaurant, and his own house. So he had covered his land with buildings, which he had done from his own effort and from his own funds. Why did you want to take away everything that he had? We just could not understand the rationale behind it. Why did you have to take his home and his restaurant and his souvenir shop? And what was the purpose? What was the national interest in doing that? And of course, it's by no means the only one, but that is the one that stuck in my craw.
I mean, it's quite disappointing to hear what you say because, it was the reintroduction of multi-party democracy, a change, all those people that had been treated badly, they would get at least redress in this part, but they didn't even get that redress. I mean, I'm just wondering, because some people tell us 1993 reintroduction of multi-party democracy, big change in the Seychelles. Was there a big change in the Seychelles?
Well, yes, there was. I think everybody must accept that there was a change. It was a sea change. There was a major change. Multi-party democracy was back. We had a constitution with a very comprehensive Bill of Rights and a constitutional court to support the Bill of Rights. Unfortunately, the hope that had been ushered in and the change, the hope that had been ushered in was mitigated to a very large extent by the fact that the same government was elected. And after a very short period of time, there was a moment from June 1993 for about a year, when things were very buoyant and open. Sadly, we slipped back into the same routine as had existed in the one-party state relatively quickly, and a lot of that initial bounce was lost. That said, certain things remained. Of course, political parties were able to exist. People, newspapers, etc. There was a seminal change. But within that change, things did not happen as quickly, as efficiently as one would have expected. And I'll give you one example. I've said it before and I will repeat it here. The Constitutional Court, in the first 10 years, instead of opening up the Constitution to be used and to be enjoyed and to be the generator of this new feeling of hope, went exactly the other way. They closed the door. They restricted the rights which had been enshrined. They closed the door to litigants and to compulsory acquisitions. The first 10 years, the Constitutional Court took a very restrictive view of what the Constitution said and what the constitutional commitment was. So that was a disappointment. Despite the fact that there had been a seminal change, a lot of that initial hope was, if not dashed, was certainly curtailed.
So the framework was there for there to be real change. So theoretically, but in practice, it was limited because it was the same people in the same places doing the same thing they'd always done.
By and large.
Yeah.
By and large, that was it. By and large, that was it. And of course, I was involved in numerous actions testing, not me personally, but as a lawyer, testing the limits of the Constitution. And the failures were numerous. It took a while. It took a while. The first 10 years were not great in terms of giving life to the Constitution and being realizing that the Constitution could be given life to without the sky falling in on everyone. It took a while, and I think it took at least 10 years before things really got going, and when we could say that the constitutional imperatives were now a matter of daily life. Even Parliament. You see, we mustn't forget that not only did the same party win the first multi-party elections, but it won with an overwhelming majority in Parliament. So, and some of the first constitutional amendments were brought in to limit the some of the gains of the Constitution.
Thank you so much, Mr. Georges, for coming again. I know we're going to see you again. I will try to schedule you at a time where you won't be changed, right? I know for Patrick Leblash, I've had to promise a time where he won't be changed because I know you're very busy and we really appreciate you coming and enlightening us. Very enlightening for me. So thank you very much. I would be interested in your file if I could have copies of these efforts that you made. I think it would be interesting for us in terms of putting things into their context when we're making our decisions, if that would be okay.
Thank you, Madam Chair. I shall make copies,
Thank
and
you.
I shall leave them with the with your office.
Great.
But please don't worry. We are all here at the service of the Commission, and we must make our best efforts to be ready when you are. We realize the amount of work that you have to do, and as far as possible, we'll try to fit in with your schedule.
Thank you very much. I really appreciate that. Thanks a lot.
Thank you.
Thank you.
Thank you very much.
Thanks. Okay, thank you. We have one more witness, I think, today, right? Be our last witness, Mr. Lebon. Can you call the next witness, please?
Mr. Lebon.
David Lebon. David Lebon.
Monsieur David Lebon.
Choose this one. Hello. Hi.
Do swear that the evidence shall give shall be the truth and nothing but the truth.
Thank you, Mr. Lebon, and our apologies for keeping you waiting this afternoon. We called you today to give some evidence before us in relation to the complaint of Mr. Aman Chang Seng, who alleges in his complaint that on the 16th of May 1986 he was suddenly forced to go on leave, and the Principal Secretary of the Ministry of National Development told him to stay away from the survey division without providing any reasons as to why. And then on the 27th of May 1986, his employment was suddenly terminated and he was dismissed from government service with no reason given. And he claims that he wrote to the President at the time to ask him why he was dismissed, and he was informed in a letter of 19th of August that his service was terminated on grounds of public interest. And thereafter, he was unable to get a job in the public service or elsewhere, except for short periods, I think, as a consultant with some Norwegian business interests. So we saw on his file that you had written him this wonderful reference, I think, in, when was it? On the 13th of April, 1983, you'd written a reference for him regarding his work in the survey division, and the Commission was just wondering if there's any evidence that you can give us about his work, so that we can try to understand that why he would be dismissed. He wasn't being dismissed because of his work ethic. So we just would like, I don't know if you've seen the reference. Did you want to see it, the reference that you wrote? Because it was a long time ago.
I think it'll be okay.
Yeah.
Actually, I made a short report about him on Mr. Aman Chang Seng. I've got the report, which I can furnish you with a copy. Well, I said I do remember Mr. Aman Chang Seng as a hard-working member of the staff of the Seychelles Survey Division. He was a draftsman who was sent by me in the capacity of Chief Surveyor at the time for further training at the Directorate of Overseas Surveys, DOS for short, in UK. He went for 1 year, and on his return, he headed the draftsmanship department quite efficiently, supervising a few juniors who were under his responsibility. It is to be noted that in the days that I was managing, 1974 to 1983, much of the work was done manually. Digitization, however, gradually increased as I had established a fruitful contact with the Directorate of Overseas Service, DOS, for assistance in various departments, including draftsmanship. Consequently, experts from there would come to initiate us, as well as our draftsmen having the opportunity of bettering themselves overseas. So it was a two-way traffic. We were sending up people to them for training. And they were sending the staff to us. Surveyors were coming here to Seychelles to help us with a lot of projects we did, including the systematic registration of plots, of parcels of land in Seychelles. I said Mr. Ameng Changsen was the first candidate to be trained and was back in office much before my resignation in April 1983, when I left for a more lucrative position overseas. That's the end of the story.
You went for another job overseas. You left.
Yeah, I had a better job overseas, yeah.
Right. And when did
it was Bahrain, government of Bahrain. You see, I'm a member of the Royal Chartered Surveyors, Institute of the Royal Chartered Surveyors. So one day I was looking at the magazine. I get the magazine, the monthly magazine, and there was this job advertised in it. So I was very lucky. I applied for it, and I was called to come immediately to Bahrain, where I went. I sat for an interview, and they asked me to start right away. I said, sorry, I cannot do that. I have to go and chat with my wife and talk to her about it, so, which is what I did. And then after that, I went back to Seychelles, and I sent my resignation, giving them about 2 or 3 weeks, the minimum, and I was off.
And what year was that when you left? Was that before he was terminated? Because he was terminated in 1986.
86?
Yeah. When did?
I think I was not here.
Yeah,
I was not here
yet.
when he was terminated.
Yeah. Okay. So I think from your evidence, he was an excellent worker. So there would be
He was good. Yeah, no problem with him. I've never had any problem with the man.
I mean, he's got quite a sad story, really, because he came before us and he really had no idea what in the public interest, what could it be? What is in the public interest to remove him, from a job that he seemed to do very well and he really, really enjoyed. I mean, he sat before us, he couldn't think of any reason, and at the end of his testimony, he thought maybe his relationship with a family, he was relatives, with a family that were having trouble with the government authorities. Maybe that he lived on in the same area. That might have been the reason.
But technically, it was a good work as far as I'm concerned.
I mean, it's a very strange case to be dismissed with no reasons, but I think this is not the only case we have, like this that was happening to people. And the only inference that I can draw is that the government of the day didn't think he was with them. That's the only thing I can think of, because a lot of people in their evidence have talked about either you're with us or you're not, right? Yeah. And I suppose if he was associated with a family or was a relative of a family that was not with the government, that might be a reason. But it doesn't seem like a very good reason, to me. It doesn't seem right.
It doesn't seem to me either.
No, it doesn't seem, because he was just quietly doing his job.
He was a good guy anyway. I can't talk anything against him. He was okay.
Were you aware at all of this, the connection with a family that was not particularly in favor of the incumbent government?
No, actually, I wasn't aware. I'm not aware of anything. Because, as I said, I was overseas quite for a long time. About 8 years I was in Bahrain. I worked there for the government to start with, and then I ended up in private practice. So I lost sight of the 7th Division the moment I left here.
Is there any type of work within the survey division which could pose a threat to national security?
I can't think of anything like that. Maybe the map, but the map is there, it's been shown everywhere. But even the map, there's nothing on the map.
The maps are not confidential.
The map is a public
Public
chart,
document,
everybody
yeah.
can buy a map. But I can't think anything else about it.
C'est Lebon, bonsoir. C'est Lebon, bonsoir.
Yes, sir.
Depuis que nous venons sortir de Barrel, nous avons sens zone avec M. Sonsin. Depuis que vous venez, tout ça le temps passé, nous avons sens zone.
Pardon, un petit peu plus fort.
Depuis que vous venez sortir Barrel, on ne va pas le temps encore.
Oui.
Est-ce que vous avez l'opportunité de joindre avec M. Sonsin, M. Mann?
Non, non, non.
Ok.
Là, moi, je viens ici, je m'en retourné. Je travaille pour moi-même. Moi, j'ai mon office, l'Inservice Office in Victoria. Par là au St. Paul, the petit building, là. That's where I was. And I worked there. But I think he was still working for the government then. I don't remember.
And it was your own practice, was it, or you were working for someone else in the private
When I was
practice?
back in Seychelles,
Yeah.
I had my own practice.
Your own
It was called Lebon Land
Uh-huh.
Service. In Bahrain, I worked for the government of Bahrain.
And when was that when you came back to the Seychelles?
What time I came back?
Yeah, remember?
Let me just see. My memory is getting a bit weak now.
I know, it's a long time ago. You don't have to remember.
Thank you.
Yeah.
Yeah, I think my memory is getting
Yeah.
a bit weak now with old age,
I don't
unfortunately.
remember when I came
Very
from anywhere. Oh,
I
That's it.
retired
yeah.
in 2012. This is I've got the I retired from the profession
Yeah.
in 2012. Back in Seychelles to start Lebanon service. Yeah, I've got it August 1991. August 1991. Back in Seychelles to start Lebanon service.
And Mr. Chang Sang never came to ask you for a job?
Chang Sang?
Yeah.
Man?
Did he ever come to ask? He
No.
never. No.
No, no, no. No, he never approached me for a job.
Okay. I don't Okay. Thank you so much for coming. We really appreciate it, Mr. Lebon.
Thank you. It was a
And
pleasure.
yeah.
Thank you.
And we don't have any more questions for you unless you have a question for us.
I don't think
No?
I have.
Thank you very. Oh, sorry. Yeah.
Yes,
Yeah. Yeah.
Yes, I will.
Yeah.
This is. Take this one.
Mm-hmm.
This is, everything I've said is.
Yeah.
is
Thank you very
Very
much.
helpful to you.
Yeah. We very much appreciate you coming. Thank you very
Thank
much.
you very much.
And have a nice evening. Thank you. Thank you. Okay. Thank you. So that concludes our hearings for today. And you have this schedule, Michael? Sorry, Commissioner Green, you want to run through the schedule? We'll just run through the schedule for tomorrow just in case.
Oui, encore une fois, pour demain, le 10 octobre, jeudi, nous prenons M. Max Racombeau, 9h au matin. Dr. Jude Gédéon, 9h30 bon matin. Monsieur Kandasamy Reddy, 10h bon matin. 11h bon matin, il y a Monsieur Jordan Nibouret. 11h30, il y en a M. Paul Michaud. Un après-midi, escante des heures, il y en a Mme Jessie Laporte. 3h, il y en a M. Dobin Samson. Il y en a aussi M. Gil Morel qui a demandé pour venir 3h30. Mais il fait nous qu'on n'est pas pour capable de venir pour une raison personnelle. Alors nous excusons et qu'il va venir l'autre fois. Merci.
And before we go, I would just like to offer a point of clarification. We were today given a, what do you call it? USB, right? A USB from Mr. Jenny, and the Commission said that we hadn't received that USB before. We had received it, we couldn't download it, but our staff could. So we were in possession of that USB stick prior to today. I just wanted to make that clarification. We will adjourn now and we will be back at 9 a.m. tomorrow morning. Thank you.
All rise.